Good day. I'm Gerald Goldfarb, and this is Inside Law. Inside Law, as you regular viewers know, is a television program where we have discussion with leading lawyers and judges in the Los Angeles community with the goal of giving the public an inside view of how the legal system really works. Many of you are exposed to somewhat fantasized and fictionalized views of the legal system in programs that appear on television like LA Law. And we hope to give a more realistic picture of what's happening in the legal system today. I'm very happy and proud to have as my guest on today's program, Mary Burdick. Good day, Mary. Mary is the executive director of the Western Center on Law and Poverty, which is really a phenomenal organization which gives and arranges for poor people in our community to have actual legal power. It's really a power for the poor operation, and it helps people who are desperately in need of help to have a real impact on the community. Mary Burdick is a lawyer herself, of course, graduated from the University of Virginia Law School in 1973, worked in private practice for a couple of years in downtown Los Angeles, but decided she wanted to devote her legal career to something more interesting than just protecting the financial interests of huge corporations. So in 1975, she became a staff attorney with the Western Center on Law and Poverty and rose through the ranks until January of 1984, when she became the executive director. Now, Mary, I wonder if, just to start off, you could give us a little bit of the background. Where did the Western Center on Law and Poverty come from?
The Western Center originated in the War on Poverty in the late 60s, and this was our 20th anniversary year. We were one of the poverty programs, and when OEO, the Office of Economic Opportunity, stopped funding us, we picked up funding from the Federal Legal Services Corporation in Washington.
And is that where you get your money nowadays?
That's our largest source of revenue. We receive over $1 million in federal funding.
And that basically comes out of the federal tax revenues that all we taxpayers pay to the government.
That's right.
And where else do you get your funding from?
The state of California has a program called the Interest on Lawyers Trust Account, or IOLTA. And they fund legal services programs throughout the state, and we receive about $130,000 from that program.
Well, just to make that clear, and I think I understand what you're saying, lawyers like myself have trust accounts where they hold clients' monies, just sort of in trust.
That's right.
And the interest on those monies actually don't go to the clients and don't go to the lawyers, but go to organizations like yours.
That's correct. When the money that you're holding for a client is in a pool that would not earn interest for the client, if you're holding the money for the client in a separate account, of course the client gets their own interest. But if it's a pooled checking account, then any interest earned goes to the state bar, which administers this funding program for legal services for indigents.
And how many lawyers are you at the Western Center?
We're 8 in Los Angeles, and we have 3 full-time attorneys and a part-time advocate in our Sacramento office.
And how do you get your cases, and what kind of cases do you handle?
We don't do any of what is called client intake. We don't see poor people regularly on an intake basis.
Organizations like Legal Aid, last week we had the director of Tzedek Legal Services. Those are organizations which see individuals who are poor and come right off the street and do one-to-one legal work. Yours is different, isn't it?
That's right. We don't do direct intake, but we work very closely with those legal service programs, including Tzedek and the Legal Aid Foundation of Los Angeles. And our contact basically comes through 2 mechanisms. First, we have what we call task forces in health and welfare, which are statewide meetings on a monthly basis in health, welfare, and every other month in housing, where attorneys from all over the state who are seeing poor people on a daily basis with problems get together, and we roundtable about recurring problems that could be resolved by one lawsuit or through one strategy. And so instead of 40 legal services attorneys each filing the same lawsuit on behalf of 40 different people, through this task force a case will be referred to Western Center. And then we will bring a suit to resolve a major problem for a large number of people, working as co-counsel with the legal services attorneys.
This is in the nature of what a layman understands to be a class action, is that right?
Most of them, or a substantial number of them, are class actions.
So you'll represent a block of poor people who have some particular grievance. How many people in such a block?
Well, one of the class actions that I worked on had 450,000 people in the class. We've worked on another case with more than 1 million people.
I see. Well, that's very interesting. And some of them, of course, have smaller numbers too.
That's correct. In fact, we can file a suit in California on behalf of one person, and if that results in an appellate court decision that a certain state law is illegal, unconstitutional, it will affect change for everyone who's impacted by that law.
So that a case for one person, if it has precedential value, will change the way thousands or even millions of people are treated by the government.
That's right.
I see. Now, maybe we can talk about some examples, concrete examples, of the kinds of cases that your center handles and the kind of impact that they have. How about, for example, we talked the other day about a case called Hansen versus McMahon, which I think is very timely because it deals with the homeless.
It does, and it deals with one of the saddest situations of the homeless, which is families who are homeless and have children with them. And during our task force meetings over the course of about a year, we were hearing over and over again that there was no special way to help these homeless families, and children were living in cars and under bridges, and that when their parents would go seeking special assistance, if there wasn't an available shelter, the parents would be told, we have one option for you. You can give your children up for adoption or to be put in foster care or to be put in an institution like McLaren Hall. And the state will pay for that. But if you want to keep your children will not be housed.
So the homeless family, which was seeking government attention, the adults were kind of put between a rock and a hard place. Is that right? I mean, either if they wanted to keep their children, they'd have to live under a bridge, but if they wanted their children to have some assistance, they'd have to give them up to strangers?
That's right, and it's not only a heart-rending decision, but it was a foolish position because it costs more to put a single child in an institution than it does to house a poor family in a motel overnight if they're having a serious problem and are having to sleep in their car for a few nights.
Well, I mean, where did this rule or policy come from? Who decided it?
Well, there was a state law that provided child protective services, and child protective services included housing for children who are in dire straits. And the state had interpreted that to mean that if the child is being not cared for by their parents, not because the parents are unloving or aren't trying, but simply because they're too poor to put a roof over their head, then those children should be cared for in the existing institutions. We thought that what the state legislature had in mind when they created that program was to keep the family intact. And we sued, and in fact we did obtain in a case where we were co-counsel with 10 other legal services programs, a statewide injunction mandating that those services be provided to children with their families and that the families be housed as a unit.
So you brought a lawsuit on behalf of these families, these homeless families. Who did you sue?
We sued the state of California.
And you got an injunction prohibiting this practice.
That's correct.
And did something follow on to that? I mean, prohibiting it wasn't really enough. That just meant they had to stay sleeping under the bridge or in their car.
Well, it didn't necessarily mean that. It meant that the family could be put in an emergency shelter overnight and that the state money would be available to pay for it. But then we kept hearing, as we were working on enforcement of this, that the real problem was that it costs so much for a family that has hit bottom to get back to the point where they can pay for a first month's rent, last month's rent, security deposit, and get back into a regular living situation, that people were forever in this cycle of shelters. And so we went to the legislature, and using our Sacramento office employees and the legal services attorneys who'd co-counseled with us, obtained passage of a bill which provided for temporary emergency shelter for the families, and then a payment of first and last month's rent and security deposit, so that if a family member could get a job, a minimum wage job, they could get into an apartment and then they could start supporting themselves.
So is this so that as a result of that legislation, there's state money available to help these homeless families have a place to live and pay their first and last month's rent?
I'm sorry to say there should have been money available, but part of the package of the legislation required that there be federal financial participation. Some costs have to be met by the federal government and some by the state. And we have just been informed within the last week that the federal government has disapproved this arrangement on the grounds that we're providing housing assistance for homeless people that is not available for people who already have a home, which of course is preposterous since people who already have a home don't need emergency shelter.
I see. There's the federal government sort of decided you were discriminating against the middle class.
Well, the poor who are housed as opposed to the poor who are not housed.
I see. So, as a result, I'm not clear where we are now. If this family, this same hypothetical family with that's impoverished and homeless, wants to get some assistance for their housing, can they get it?
Well, where we are right now is if they go to their county welfare department, they can get this emergency temporary assistance that we won in the lawsuit. We are hopeful that by negotiations between the state and the federal government, between us and the federal government, this may be resolved without further litigation, and that we can get activated the program for first and last month's rent and security deposits.
But that really depends on. The problem here is the federal government doesn't want to put money into these kinds of human needs.
That appears to be what's happened.
I thought so. Now, I know very recently you actually argued a case in front of the United States Supreme Court. Is that right?
Yes, I did, on a case that I filed in 1976, and now I hope we're finally coming to the end of the line.
So 12 years ago the case was filed and it finally got to the United States. They say the wheels of the law grind slowly.
Very slowly.
Well, I think it's exciting, though. I've never been in front of the United States Supreme Court. How did it make you feel?
Well, it's interesting. Once you get over being nervous and once you start arguing, you realize that the justices are not there on display. They aren't interested in pomp and circumstance. Those people are trying to resolve very serious problems, and they're in their office, basically, when you're arguing with them, and they're seeking your help to understand the issues and your help to reach the right result. And once the argument starts, it's a fascinating process, but it's not. It doesn't make you as nervous as you would expect. It doesn't impress you with its grandeur while you're doing it. And then when you're done, you think, "My gosh, I just argued in the United States Supreme Court."
Well, that's thrilling for any lawyer. How did this case start a dozen years ago?
It started with the oil crisis. When the price of oil went up in the late 70s, Congress enacted a special program where the federal government would pay for increased heating costs in certain kinds of federally subsidized apartments, so that the people who lived there, who were all low-income people, wouldn't have to pay the increased costs. And for a reason which I have never understood, the administration decided that instead of paying for the subsidies, it would just keep the money, and the money accumulated and accumulated. When we filed suit, they had $45 million in a reserve fund for this purpose and wouldn't spend it. By the time the suit was over, they had $60 million and wouldn't spend it.
Well, I mean, the money for these heating subsidy payments accumulated, and the government wouldn't spend it, even though the legislation said they should. I mean,
they wouldn't spend it, and they weren't permitted to spend it for anything else. The only thing they ever told us.
Why wouldn't they spend it?
What they told us was this only solved the problems of increased heating costs, and there were other problems in subsidized housing that they thought needed addressing. Well, I agree with that, and Congress probably agreed with it too, but what Congress was trying to do was address one problem at a time.
Well, this was basically bureaucrats in the federal government who were not complying with the will of Congress, wasn't it?
Pretty simple, they weren't.
And so you had to bring a lawsuit to oblige them to do so.
That's right. We filed a nationwide class action. We won in the district court. They appealed, and it went up on appeal, and eventually we settled after a change in administration. And the $60 million was made available for back payments to people who had to pay the increased costs in order to allow them to recoup what they had suffered.
And my understanding is that you folks at the Western Center actually administered the distribution of this $60 million. Is that right?
We did. There were two of us at Western Center. There was an attorney who had had a similar action in Connecticut, and there were two attorneys from private firms in Los Angeles who volunteered pro bono services, and we made a 5-attorney committee. We worked with the accounting firm of Price Waterhouse. We set up a claims processing center. We went through 450,000 claims, approved 150,000, and eventually distributed the money.
You basically distributed $60 million to 150,000 people who had, who in the first place, many years before, were entitled to the money.
That's right.
Well, that's kind of a happy ending, isn't it?
It was, and we received an awful lot of very gratifying letters from people all over the United States, many of them elderly, who opened their mail and finally, after 5, 6, 7 years of waiting, had received on an average $150 to $200, which is a tremendous amount of money for a low-income person on a fixed income, and people were buying glasses and other things that they couldn't afford before.
Well, that's remarkable. But if that's all been accomplished, why is this case recently in the United States Supreme Court?
Well, at the end of the case, we moved for an award of attorney's fees, which would be money that would go to the Western Center to fund additional cases. In 1981, Congress passed what's called the Equal Access to Justice Act, and for the first time made the federal government responsible for attorney's fees if it litigated a case where it didn't have a strong position and ultimately lost, in order to encourage the government to examine carefully the merits of the cases, to settle cases that were weak, and not to force people to litigation unless they had a strong case.
And so, if I understand the situation correctly, the district court awarded the Western Center and perhaps its colleagues $1 million in attorney fees, and then the Ninth Circuit reduced that to $320,000, but the government still wasn't content, so that's why it's in the United States Supreme Court to try to stop the Western Center for getting attorney fees for this magnificent job that you did, right?
Well, it's there because the government doesn't want to pay attorney's fees to the Western Center, and also because they're trying to get the Supreme Court to set what I think are very low standards for their conduct. They're asking the Supreme Court to deny fees unless the prevailing party can show that the government had a case that was so weak that they didn't even have a fair chance of convincing one single judge ever that they should prevail.
Yes, but isn't this really an underhanded way of the government trying to discourage people from disputing them in the law courts?
I don't know if they're trying to discourage people, but they're certainly going to if fee awards are not available.
Wonderful. I'm interested in a case that I know has happened recently regarding Medi-Cal reimbursement rates. It's my understanding, was my understanding, is that here we are in a civilized country in Los Angeles, California, and a civilized city, and that we have a Medi-Cal system, and that people who are poor, maybe they don't get Beverly Hills medical services, but they get adequate medical services. And I'm understanding now that I'm somewhat mistaken, and that the Medi-Cal system really doesn't properly and adequately take care of poor people. Maybe you can explain that to me a little bit, and we'll talk about the litigation in that area.
One of the things that we were hearing when we had our health task force meetings with legal services attorneys was that in many counties in this state, the Medi-Cal reimbursement rate is so low, that is the amount that the doctors are paid to care for people on Medi-Cal. And the paperwork is so burdensome, resulting in maybe 6 months delays in payments, that many doctors simply won't accept Medi-Cal patients. And in some counties, we found that there was not a single dentist who would take a Medi-Cal patient, and that there was not a single obstetrician who would provide prenatal care to pregnant women if they were on Medi-Cal. So these women are entitled to medical care. There's a fund to pay for it, but the fund is so inadequate, and it's such a pain in the neck for the doctors that the doctors just won't care for the people.
So the woman who's pregnant is not going to get prenatal care, even though she's entitled to it.
That's right. We've had some clients who would have to travel more than 100 miles to get to the only obstetrician who would see them in an area where it's in the mountains and there's no public transportation and they have no car. Basically what it means is that poor women on Medi-Cal do not see a doctor until the day they deliver their babies.
And tell me where they deliver their babies.
They deliver their babies in the emergency room, in the halls of a county hospital, or maybe even in the parking lot because they aren't able to get through the red tape to get in the door.
So that giving birth to a child for these people really becomes an emergency situation instead of a normal life situation because they can't get medical care. And I know the same sort of situation applies to dentists. If I'm not mistaken, although you're entitled to dental care under Medi-Cal, the money's paid are so low that dentists won't fill your teeth. Is that true too?
That's right. We found some counties where there's not a single dentist who will take care of gum disease problems for people on Medi-Cal. And so what these people do is they live in chronic pain until their teeth fall out, or until they can find someone who won't treat their problem but will at least jerk a tooth for the Medi-Cal rate.
I see. So it's jerking a tooth. That's a kind of an inexpensive way to do things. So dentists might be willing to do that for the Medi-Cal rate, but not to try to preserve the tooth.
That's right. The kind of treatment that people need for gum disease or for root canals, dentists simply won't provide in many counties for the dental reimbursement rate.
Well, what has the Western Center done about these problems?
We have just recently filed suit, and we will be going into court, and we'll see what happens there.
Well, who are you suing, and what's the purpose of your suit?
We're suing the state, and the purpose of the suit is to increase the reimbursement rates. I would suppose at the earlier stages we would be hoping for some analysis to be produced by the state of what reimbursement rates are necessary to in fact induce doctors, and then an increase to a rate that will in fact cause doctors to participate in the program.
And well, that would certainly be a good result. And if I understand it correctly, single men have a particularly difficult problem in terms of getting medical services under Medi-Cal. Is that right?
Well, anyone who doesn't qualify for what's called one of the categorical welfare programs can't bootstrap onto Medi-Cal. For example, if you are a single woman with a small child and you can get through the administrative hurdles and you qualify for aid to families with dependent children, then you also qualify for Medi-Cal. But if you're, for example, just down and out on Skid Row and don't qualify for one of the categorical benefit programs, you haven't been found to be permanently disabled, you don't have a child under a certain age in your custody, then you're just on county care. And when you're on county care, you don't even get the Medi-Cal healthcare system.
I see. Well, it's really a bureaucratic nightmare, isn't it, for someone who is really ill-equipped. Those of us who are poorest equipped to deal with the bureaucracy have the greatest bureaucratic hurdles to get over.
In one of our suits, we had an attorney just follow a person and try and go through the process of applying for some of these things. Something like 25 to 30 to 40 forms and steps. We took those to the judge, and the judge said he couldn't understand it either.
The judge couldn't understand it, and the poor person is supposed to understand it. It's great. We don't have much time left, Mary. It's a real interesting conversation for me. I just want to spend a minute or two at least on the fact, if my notes are correct, you became the director of the Western Center in January of '84, and 4 days later the government tried to cut your funding, were eliminated. Tell me briefly, what's the dynamic between the Reagan administration and groups like the Western Center?
We've had a very poor relationship with the Federal Legal Services Corporation and the Reagan administration. In '84, they tried to take all of our funding away, as you said, and we ended up suing them in federal court, and our funding was restored. That same year, Senator Cranston inserted a line in the Legal Services appropriation to guarantee that we would be in existence the next year. And since then, every year, Congress has had to mandate that the Legal Services Corporation continue to fund support centers, and every year the Legal Services Corporation votes to eliminate us and then is overridden by Congress.
So you have a continuing problem, don't you, of federal supervision and of federal funding?
We do. We have a very serious problem.
Maybe if we get a Democrat administration, then maybe things will go better, but you never know about that either, do you?
I think any other administration things would go better. In fact, the Republicans have been the strongest supporters of continued funding for legal services.
Well, I appreciate this conversation quite a bit, Mary. It's been educational for me to know what the Western Center is doing, and I think it's been educational for others. I want to shift gears now a bit and do another feature of our program, which is an opportunity that I take to do a bit of commentary on legal problems that are arising in our country. And I think this is something you'll probably be interested in also, Mary. What I want to discuss today is a case that just came down from the United States Supreme Court last week called Hazelwood School District versus Kuhlmeyer. And basically, the facts of the case are that a high school newspaper in Missouri wrote articles, or wanted to write articles, on the problems of teenage pregnancy and the impact on teenagers of divorce. And the principal of the school forbade the student newspaper from publishing that material. The students sued. They lost in the United States District Court. They won in the United States Court of Appeals. And just last week, they lost in the United States Supreme Court by a 5-3 vote. The court, by Justice White, said, "We hold that educators do not offend the First Amendment by exercising editorial control over the style and content of student speech in school-sponsored expressive activities, so long as their actions are reasonably related to legitimate pedagogical concerns." In other words, Justice White said that school principals can censor school newspapers. The dissenters, led by Justice Brennan, took a very different point of view. Justice Brennan said, among other things, "Such unthinking contempt for individual rights is intolerable from any state official. It is particularly insidious from one to whom the public entrusts the tasks of inculcating its youth and appreciation for the cherished democratic liberties that our Constitution guarantees." My point of view is that Justice Brennan is right and Justice White is wrong. The articles in question were not obscene, they were not rabble-rousing, they were not libelous. They were very legitimate and responsible inquiries into subject matter which is of legitimate concern to students. That is, teenage pregnancy and the impact of divorce. It occurs to me that these are the kinds of subjects that students ought to be discussing and dealing with in their publications so that they can work them through and come to some form of reasonable conclusion about them. If you cut off this legitimate realm of student discussion, what kind of a message does it give to our students? It must push their energies into some other direction. It seems to me to really be a totalitarian kind of situation if student newspapers can't say what they want to say about legitimate discussion subjects. And I think also it's part of a larger trend. In recent years, the Supreme Court has ruled that the Fourth Amendment prohibitions against unreasonable search and seizure don't apply to high school students. They've ruled that the right to free speech, to make a public speech in assembly, doesn't apply to high school students. Now the free press is eliminated. So I think this is a problem we all ought to think about in dealing with our Supreme Court and dealing with our schools. I want to thank you all for watching our show today. I hope you've learned something about how the legal system works, and I hope that we've been somewhat thought-provoking. And this has been Inside Law. Our special guest was Mary Burdick. I'm your host, Gerald Goldfarb. Please feel free to write to this station if you have any comments on our program. Thank you very much, and good day. For further information, please call Inside Law at area code 213-285-8599.